on paper, someone sees my degrees and thinks BA, MA, JD, he always wanted to go to law school. It's obvious that he was just following a linear path. It was anything but.
Let's say you look at a case and a client comes to you and you're like, oh man, this doesn't look too good.
The most important skill for a litigator is to learn to be reasonable. Judges want a reasonable path where you acknowledge the faults of your case at the outset and you address them. Everyone's got their boxing gloves on in litigation and everyone wants to punch. And it's very easy to fall into the trap of, I'm just going to punch for my client and I'm going to take silly positions.
So having been a partner for years now, Marco, how has your perspective on the practice of law evolved?
It's actually wild. I think it's a huge transformation, and I'll tell you why. I would say don't be afraid to make yourself vulnerable. And so fundamentally what that means is doing things like you've just done, Mo. I don't know you. I didn't know you. And you're like, hey, I'm running this podcast that's hopefully going to provide some guidance to younger generations of lawyers.
How would you like your legacy to be remembered? What would you want to be remembered for and kind of your contributions?
Wow, that's intense.
Welcome to Billable Time, a legal podcast where I talk to incredibly fascinating people in the legal industry. Today's guest is a partner at Torkin Manes, where he focuses on civil appeals and judicial review as an appellate and public law litigator. He is the chief editor of Torkin Manes Legal Watch, sits on the Canadian Institute's Advisory Board for Administrative Law, and has been widely recognized for his legal writing and thought leadership in appellate and public law, including multiple Lexology Legal Influencer Awards and the Mondac Thought Leadership Award in Public Law. Ladies and gentlemen, Marco Falco.
Thank you. What an introduction. It's another honor to be here. First of all, props to you, Mo. This is incredible, and I wish more law students took initiatives like this to start these types of podcasts. So I sincerely want to congratulate you for doing this. This is incredible. And I also want to say hello and congratulate our articling student, full disclosure, Mario Articles at Torkin Manes. So we do know each other. And he has the misfortune of having to work under me in the litigation rotation when he's there. So welcome, Mario.
Thanks, Marco. Thanks for taking the time.
Yeah, we're gonna give Mario his introduction in a little bit here. I got a special speech for him in a second, but nonetheless, thank you both for taking the time to join me, and thank you for the kind words, Marco. Really appreciate it. But with that being said, I think one of the goals of this podcast is to talk to thought leaders from all backgrounds in the legal industry. And I have to say, when I was doing my research on your legal career, I found your decision to go to law school to be just an incredibly fascinating one, because it was one of, finishing up your master's degree in English, like a genuine, I am trying to do English instead of some people just doing it as a pre-law degree, but finishing that master's in English, having academic ambitions. I'm curious to know, how did that path ultimately lead to your current career in the legal industry?
It's actually funny that you raised this. On paper, someone sees my degrees and thinks BA, MA, JD, he always wanted to go to law school. It's obvious that he was just following a linear path. It was anything but. I'm actually an accidental litigator in some respects. So I was doing a BA and MA. English literature, as you can see from behind me, is my passion, my love. Literature is my love. And I really wanted to be an English professor. That was where I wanted to be in the early 2000s. Unfortunately, the job market for humanities professors wasn't particularly great at the time that I graduated. And so I wanted to do American literature. There were sort of various areas of interest. I'm not going to bore you, but Black American literature and effectively British modernism and maybe some Chaucer in the mix, whatever I was wanting to pursue. And there were a number of institutions in the United States that I would have had to have done a PhD at in order to acquire a decent job. And some of my professors who were incredibly life transforming in their mentorship said, look, you've got to get into one of the Ivy Leagues. Like if you want to do this seriously, you can't just keep on coming to U of T and we love you, but someone else has to make sure that they love you too. So I didn't get in. I wrote all my GRE exams. I did everything, and I didn't get into Harvard. I didn't get into Yale, and I think I got shortlisted for one, but with no money. So effectively, I didn't get in. Um, and so I had a cri de coeur. I accepted the PhD program at U of T in English. So I thought, okay, I'm not setting myself up for the best job market, or sorry, for the best job in terms of having 3 degrees from the same university as an academic. That being said, the Department of English at U of T was world renowned and great at the time. But I had banked my LSAT as an insurance policy, being a sort of middle class kid of immigrants who didn't have a lot of money and resources. So I kind of banked my LSAT as an insurance policy, and it was always in the back of my mind. I'd written it, I don't know, in second or third year, and I had this cri de coeur, really, just at about, I think, the tail end of the academic year at the end of my master's. And I thought, I've just accepted the PhD program. What am I doing? Like, I don't know if I'm going to end up with a job at the end of this. I don't know if I have the luxury of not having a job at the end of this. And this is a lesson into why you're always nice to administrators in public institutions, but I begged and pleaded. This was my first sort of foray into litigation and advocacy. I begged and pleaded with one of the administrators to take a late application at U of T Law. And I don't know what magic she worked. But within a couple of weeks, I was accepted. And then I had this moment where I was walking in parks and I'm like, what am I going to do with my life? I don't want to be a lawyer. Why am I doing this? I really want to be an English professor. Um, I accepted U of T Law. I rejected the PhD program in the end. And then I sat in law school for the first 2 to 3 months. And despite the social aspect and having met some of my closest friends to this day at law school, I really reluctantly sat in those classes and wondered, why am I studying torts, contracts? Who cares? I want to be studying Shakespeare. I don't understand why I'm doing
So
this.
this was even after you've taken a couple months in, you're still in
Oh,
that.
yeah.
Why am I even here? That's
Why am I
insane to think.
here? I
Wow.
was resentful. I'm like, this is an expensive degree. I don't know what I'm going to do with it. I don't know that I want to practice law. And then in about February, I had amazing professors at the Faculty of Law, just as I did in English. I was really lucky. And one of my professors said, look, a light bulb is going to go off in February, and you're going to sort of understand how these 5 or 6 courses in basic law that you're taking are going to come together, and you're going to understand them as an intellectual exercise. So the light bulb did go off. And I finally sort of understood what I was doing. And in that process, I learned that law could be as intellectual as English. The same sort of skill set that I was learning in my studies in English was effectively being applied in a new way in law. And I kind of learned to love that. And that's how that sort of evolved. And then, here we are. And like Mario, I summered and articled at my firm. I've been there now, God, I don't want to think about it, 2 decades at least. And worked my way up from, summer student to partner. And here we are. And quite frankly, I love my job now. I wouldn't have envisioned this for myself by any stretch of the imagination. If you had asked 22-year-old Marco where he was going to be. He was going to be teaching at some liberal arts college, probably in, the upper US and teaching literature. And here I am, an appellate advocate and a public law lawyer, and incredibly fortunate for the career I have.
Wow, that's a heck of a story in terms of, I guess, not only taking a chance, but also letting things play out. I think a lot of times, I know me and Mario come from different backgrounds prior to going into law school, but even as someone in the media space, like leaving the CBC to come to here. I was like, what? I was like, what am I? I was like, what's going on? And like you mentioned, I think that second semester 1L is when things start to really click. But joining me today, I think I feel like I'm watching the passing of the torch here, like of one Torkin Manes litigator to another. He is everyone's favorite contract law TA at Windsor Law. A 3L dual JD candidate at the University of Windsor and the University of Detroit Mercy. Like you mentioned, Marco, he's an incoming articling student at Torkin Manes, and actually, believe it or not, a seasoned mooter at Windsor Law. A finalist at Windsor Law's most prestigious moot, the Zuber Moot competition, and the winner of the 2024 Transnational Moot competition. And to round things out, he was also the second most valuable Batoni in this year's Windsor Law All-Star Soccer Game. So, what an incredible roster. But nonetheless, all jokes aside, it's a pleasure to have Mario Batoni joining me.
Thanks, Mo. I think I'm the only dual JD contracts TA, so I don't think it's hard to be the favorite. um, but Marco, having spoken a bit about your background, how do you think that studying literature and kind of your undergrad degree has influenced the way you write and reason and kind of advocate now that you're an appellate lawyer?
I mean, the skill set's actually easily translatable. I literally on Wednesday was at the Department of English doing a career in law seminar. So for anyone out there who attended that, I'm sorry, but I'm going to be repeating myself slightly. But look, the fundamental skill set that I learned studying literature was reading, writing, and speaking. Mo, you would know this having worked at the CBC. And taking that skill set and then translating it into a career where basically I'm making written submissions or oral submissions to some very smart judges. That's an easily translatable skill. So the other thing that studying the humanities, and I'm a big proponent of this, I don't believe any of the sort of garbage out there about the liberal arts being useless and where are you going to go with this. There are actual studies that show that liberal arts students actually fare better in their career than science and business majors in the end. They might start off with lower income, but ultimately they catch up. And the reason is you're taught to think critically. With literature as well, you're being thrust into a whole series of new worlds. Like no one speaks Middle English, to my knowledge. So when you're reading text from Chaucer, when you're reading a piece of literature in Italian that's completely and utterly foreign to you, you adapt quickly. And you have to critique it, and you have to think about it, and you have to provide a critical analysis. That's the same skill set in law. And Mario, you know this, having worked on several files with me last summer, that, one day we're doing civil sexual assault, the next day we're doing commercial litigation, and the next day we're thrust into, some sort of administrative law dispute. The thing that a humanities degree, in my view, does is it exposes you to all these various different disciplines and texts and asks you to sort of think about them in a different way and then come up with a theory and present it. That's exactly what we do as litigators. And I don't see a difference in that skill set. And that ability, in my view, to think and analyze critically will become more and more important with the advent of AI. I'm not one of these AI doom and gloomers who think that they're just going to replace everyone's job. At the litigation and lawyer level, I think there is going to be much more room for people who can divorce themselves from what they see on the screen and question it and question its veracity and challenge it. That's the sort of skill set you get with a humanities degree, in my view.
Wow, that's an incredible insight. And the last time I read something like that, I was just grabbing one of a book that I read a couple years ago. This guy happened to mention, the same thing in terms of just like the importance of the humanities and how that leads to critical thinking and whatnot. And that was something that I found really compelling. Even Mario brought up, even just in our discussions before. And so transitioning out of like the pre-law and law school phase, I mean, right now you are an established lawyer within the appellate litigation space, but I'm curious to know what those early experiences were like as a lawyer and what helped you stand out early in your career, especially considering not many people, I guess, stay like last long in one particular firm or one particular practice area. I'm wondering what those early experiences were like, and what do you think helped you stand out earlier in your career?
I mean, it's an excellent question. I think I had, particularly as a young associate, a real serious imposter syndrome. Not to reiterate the theme, but I'm the son of middle class immigrants from Downsview. I went to public school. I'm LGBT. So I walked into a firm where, no one in my family had been a lawyer prior to me. Sorry, I think I had a cousin who had just gotten in, but the chronology wasn't long enough to be meaningful.
Shout out to
Uh,
Marco's cousin. We acknowledge you. You're one of the Falcos that got in as well. So
exactly. So I really I didn't know what I was doing, genuinely. And so I spent, I think, a lot of my time questioning that. But one of the things that I think was my saving grace, particularly at my firm, was that I had a series of mentors in the litigation department who slowly but surely started taking me to court. And I would sit there and observe. I wouldn't speak for years in a courtroom. I was too terrified. I wasn't sure of myself. But I found the two or three lawyers who, one of them now being a judge of the Superior Court, who believed in me and took me under their wing and said, look, this is how you present an argument effectively and cogently in court. You're going to learn from my mistakes. You're going to learn from what I do right. And I made many mistakes along the way. There's absolutely no question about that. And the reason I do so much mentorship now is because I want people to learn from those mistakes. Litigation is not intuitive. Everyone sort of thinks that there's a rigid and mechanical way to do things, but fundamentally, and we'll touch on this theme later, I'm sure, in our discussion, but what you're doing as a litigator is trying to help the judge get to a certain result, preferably yours. But you're there to assist the court. That's your fundamental role. And it took a lot of sort of observation of the sort of bigwigs in my firm, uh, and watching them in court and watching what worked and watching what didn't to sort of realize this is what I want to do and how am I going to forge a path to get there. So I spent sort of, the first few years learning the tricks of the trade, but as I often tell my mentees, the first few years are also the lost years. You're learning, but you don't know what you're doing and you don't necessarily know where you want to be. So you're acquiring the skill set. And then I would say midway through your career, as an associate, you have to pivot quickly and realize like, this is what I want to do. This is what I'm committed to. How am I going to get there? It was, again, a longer journey. There were many setbacks. There were many mistakes that I made. But here we are, and I continue to make mistakes, and I continue to learn from them. As Mario has seen me in court, so he'll attest to that in any event.
You know, meeting last year with you, Marco, in preparation for the competitive moots at Windsor, um, that role of the advocate to help and assist the court kind of stuck with me, especially when you had mentioned to us about some of the best benches being the most interventionist, and it kind of resonates that sometimes you're just telling the judge the holes in your case so that when they do come to the decision and it's in your favor, that they know kind of how to plug those holes. So I find that point very interesting. And kind of while we're on the point of a path and kind of figuring things out, I'm curious to learn a little bit more about your path and how you kind of got into appellate advocacy. You don't hear too much of it in the civil space. It's a lot more in the criminal law space. So how did you kind of get involved in appellate advocacy? And how did your approach to advocacy change once you kind of moved beyond the trial level to work in appeals and judicial review?
Yeah, I don't think my path was intuitive at all. And again, I kind of stumbled into this, and I'm grateful that I did. It's an excellent question. I effectively was the humanities major in the litigation department at the time. So everyone was like, well, Marco's got 2 degrees in English. Just feed him reading and writing. He can write a bunch of opinions and so forth. And I did that for many years. I was sort of in the background. I was in the shadows. I was watching, I was observing, but I wasn't speaking. So I kind of, it's sort of unusual, but because of that, for lack of a better term, and I think I'm inflating what I actually did, but because of that quasi academic role that I played in the litigation department, rather than sort of, running a bunch of trials myself, I would attend them. And more important, I would attend divisional court hearings and court of appeal hearings. And I would watch really good litigators in our department. Mario, you know who they are. I would watch them in court. And slowly but surely, I realized I want to do this. Like, I'm tired of tugging on the ropes as, an associate and telling people what to say, or tired of helping them draft their factum and then watch your arguments get debated, but you don't actually have the luxury of debating them yourself. So that was when I sort of forged a plan to say, okay, what do I do best here? I go to the divisional court with my senior litigators and I go to the court of appeal more often than not, less so at trial. And so, there's certain advantages to that because I'm inclined to think about and write about the law. And those courts, just because of the nature of what they do, are more are susceptible or more amenable to debating legal principles as well as the record, of course, and the facts. Courts are trying to do equity at all points. So slowly but surely, I started to speak up myself. And then, after a few rounds of getting beaten up in both courts, I stood up on my own 2 feet, and now I'm a regular in them, much to the judge's chagrin, I'm sure. But now I've created this path for myself. The point being that if you're a young lawyer in a firm and you're gravitating towards a particular practice, then gravitate towards it. Set it up for yourself. Sit down and say, I want to be a construction lawyer. How am I going to do this? And think about the plan to get yourself there and forge ahead. And so, start getting acquainted with partners in the industry, in the area that you're interested in, and take it upon yourself to start talking to people. And I did many, many coffees with senior litigators who had done appeals, many judges, just sitting there and listening to, what makes for an effective advocate. And having done those hundreds of coffees, all I was doing was learning. I was absorbing. I was a sponge. And those people who were so gracious to take the time to do this for me helped me create my career. And now I get retained by clients and so forth to run their judicial reviews and appeals. And here we are. I did face setbacks. There were certainly people who questioned what I was doing because at the time, particularly when I forged this, appellate advocacy in the civil field, Mario, as you said, is not particularly common. JRs were in administrative law, of course, but appellate advocacy, now we have a group apparently at the Advocate Society. There's a special OBA group, I think, that's forming. So people are starting to realize that this is a highly specialized skill set, and therefore we need specialized lawyers. And clients are realizing that as well. Your trial lawyer and your appellate lawyer do very different things. I was just explaining this recently to some of our colleagues at Torkin Manes, who are corporate lawyers and didn't understand. They're like, I don't understand what you do. Why can't the trial lawyer just appear at the appeal court and argue the same case? I'm like, number one, they don't have the necessary distance. But number two, I'm not cross-examining people. The record is the record by the time I get involved. What I'm looking for are either errors of the underlying judgment, or I'm trying to defend it and say why it's right in law. It's a very different skill set. And I think slowly but surely the Ontario bar is starting to appreciate it. So that's how I landed where I did. I just basically created my own road.
Wow, and it's super compelling to talk about appellate litigation because all the moots that we do in law school, it seems to be just there's a landmark case and then you appeal it. I remember I was talking to someone about appealing a Supreme Court of Canada case. I'm like, are we appealing to God? Like, who are we? Who else are we appealing to? But nonetheless, given law students, we all have a sort of appellate litigation as our primary outlet for mooting, and even just would love to know in general about that experience on your end. Like, what are the most effective ways you find to clearly and persuasively get your point across, especially when, let's say, you look at a case and a client comes to you and you're like, oh man, this doesn't look too good. I don't know if I should, but you end up taking it and then you end up succeeding with it. Specifically in those instances, what do you find are the key facts that help you get your points across?
I think the most important skill for a litigator is to learn to be reasonable. Everyone's got their boxing gloves on in litigation, and everyone wants to punch. And it's very easy to fall into the trap of, I'm just going to punch for my client and I'm going to take silly positions. And, I'm going to run to court and I'm going to be as aggressive as I possibly can because the client's paying me and they will see that I'm aggressive and we're going to win. That's not what judges want. Judges want a path, a reasonable path where you acknowledge the faults of your case at the outset and you address them. So you, of course, advocate the best possible arguments, and the rule of thumb still applies. Best arguments first, always. But in the process, you recognize like these are the flaws, but I'm going to tell you why the flaws don't matter in this case, and why we can advance a better case on behalf of our clients, where we've recognized the errors that in the conduct that they may have engaged in, or in the equities. I think if you present your case that way, number one, you garner the respect of the court. The judges will respect you because they're realizing you're being forthright with them. Like, I get what you're struggling with, Your Honor. But I'm going to tell you why that doesn't apply. And they can accept it or not. But the point of the matter is, I find in even the cases where I've got the sort of, highest hurdles ahead of me, and, there are a few that come to mind in my brain that give me anxiety. Um, Even when I've got those highest hurdles, I will only earn the respect of the court and maybe have a shot at this if I fresh off the bat say, I understand why my position may seem radical, or I understand why the judge ruled against my client, but I'm going to tell you why there were some serious mistakes in that. And I think if you take that reasonable position, and this goes back to the theme that Mario touched on before, if you're there to help the court, they're more amenable to your ideas.
Even now prepping for competitive moots, you kind of see all the competitive mooters in the law school trying to figure out their positions. And I think that goes a long way because a lot of times, um, I don't know if it's just law students or just inexperience, you kind of get stuck on a position, you're sold in your argument, and you kind of dig your heels in. And it's not necessarily the best thing. And even working in the summer, I noticed that. And I think it goes a long way, like you said, Marco, that courts can see that you're credible and you're not just trying to force your position on them as well. Um, I guess building off that, at what point did you feel like you developed your own voice and that you kind of had that confidence to appear on your own as an advocate and you kind of knew exactly what your style was?
I mean, look, I would say the first time I sort of was thrust into a file where someone said, "Go to the Court of Appeal. You've been doing this enough. Like, just go." It was a bit of an unmitigated disaster in some respects. I actually half won the case and half lost it. The appeal was allowed in part, but I really didn't. I didn't know what to expect. I didn't know what I was doing. And the thing that I always say to people is like, make yourself vulnerable. Do more moots. And trust me, I didn't moot. I'm a litigator who never mooted in law school. I was terrified. There was no universe in which I was going to do this voluntarily. I did the, mandatory moots that we had to do in law school. And I was like, I will never do this again. And, here I am, regularly appearing before the courts now. So my sort of suggestion to people is if you're scared, the more you do it, the less scared you become. And don't get me wrong, I'm 22 years out. Every time I stand up at that bench at Osgood Hall, and Mario, you've come to court with me at the Court of Appeal, my hands are trembling. My voice is shaking for the first 2 seconds. It always is. That anxiety never dies. But what I can do now is, after about the first 30 seconds, when I'm acclimatized to myself, I realize the people in front of me, as one of my professors used to say in law school, are not gods. They are human. They are fallible. They have their own particular concerns and ways of thinking. And so I'm there to simply have a discussion with them. And other than opposing counsel, no one else in that room knows the file better than I do. So I have to remind myself of that. And, if you're polite, if you're calm, if you're reasonable, even in the face of, a lot of judges that, well, sorry, I shouldn't say a lot. Even when judges are struggling and, they may have had a bad morning and suddenly, you're getting heckled as a litigator, you stand firm in your position, but in a way that's polite and respectful. And if you see that you're not gaining traction, move on. Go to your next argument, and address it that way. Those are sort of the tricks of the trade. I think I've digressed completely from the question you originally asked me, so I apologize. This is how my mind works. But that's how I created a voice for myself. It's sort of, there's a lot of things I do to sort of quell the anxiety of litigation. And I think anyone who tells you from a mental health perspective that litigation doesn't take its toll is lying to you. It does, 100%. But, I've got coping mechanisms. I have an amazing, spouse, my husband. I have supportive friends who are incredible. I have an incredible family behind me. I'm lucky that way. And I do a lot of sort of extracurricular non-legal activities. Even Mario, you know this. Do not book Marco between 2 and 3 p.m. For any meeting, because I will not attend because you will find me at Good Life for an hour. And that is my sacred hour every day. And unless I'm in court, nothing is going to interfere with that.
For the record, having attended with you, you couldn't tell about the anxiety or nerves or anything.
Thank you. Thank you for lying.
Yeah, I was gonna say it's such a fascinating thing to hear someone that's well regarded and accomplished in the field deal with the same struggles, a first year law student. I'm sure Mario maybe remembers the fables of me in my first mood competition. May it please the court, just like out of just sheer anxiety, right? But it's incredible to hear that the acknowledgement this exists, but at the same time I deal with it in my own way. So I thank you for sharing that specific note in particular. But regardless, I just wanted to ask in terms of, you mentioned you had colleagues and mentors tell you, different things and about, not like little advice of these aren't gods. These are just human beings. And I'm curious to know, building on that mentorship angle, what habits, it could be techniques, it could be strategic approaches, did you learn from, your mentors, either at the firm or elsewhere, that have stayed with you throughout your career?
I think, there's this sort of practice of law. So that was largely filled internally at my firm by, I had various examples of great litigation and great litigators. So, learning the sort of tricks of the trades, what works, what doesn't, that happened internally. Externally, I went out and started talking to people and doing coffees and meeting people and had people guide me. I once had a lawyer who I know had done a lot of Supreme Court of Canada advocacy, and he happened to be in town from Ottawa, and I met him for a coffee. And he said to me, he's like, Marco, this is how I draft a factum. And literally gave me like his formula, his secret sauce. And I was like, oh my God, why have I not been doing these? And, it was like having these discussions with people outside your firm that were just as important as the ones where you're forging your career. Um, Making yourself vulnerable and asking questions. You would be shocked how many lawyers and judges in this profession are willing to give up their time to sort of take people under their wing. Lawyers love that because we love enthusiasm. We love looking at people of your generation and seeing that drive, that sort of inner kernel that runs on the adrenaline of litigation, and thinking, I want to see this person succeed. I want them to be a litigator in 10 to 15 years. And I want to help them get there. And so lawyers will be particularly generous with their time. I don't need to, tell you who these people are. Mo, you interviewed one last week. My friend Peter Saad, who is my friend, but even though, I think he's younger than me, I also regard him as a mentor, because we have so many discussions about how we navigate things within our firms. He's a corporate lawyer, so obviously not from the litigation angle, but it's so nice to have met someone literally by way of social media. It's just like, I have a lot of problems with social media, but the one thing it has done is put me in touch with people like Peter Sod, people like you, Mo, who sort of allow me to learn while I'm teaching, if that makes any sense. So people will come to me and ask for mentorship, and it's really funny because at the same time that I'm providing them with advice, I'm learning so much about the challenges that they're facing and how they confront them. And also, I'd like to have my ear to the ground because then young students like Mario walk into my firm and, I don't know what their perspective is anymore. I've been divorced from law school for 20 something years. And so I don't know what they're looking for in a career, what they think litigation is anymore. So, having the ability to mentor people is as much a learning opportunity for me as it is for them. And it's funny because people say, "Oh, it's such a thankless enterprise." I'm like, it's kind of selfish. I'm learning more from your generation than, I necessarily did from my elders in some respects.
So having been a partner for years now, Marco, how has your perspective on the practice of law evolved, kind of from the associate level now to the partner level? And in particular, if you can kind of touch on whether it be judgment, responsibilities, mentorship to new associates, anything like that, and how what differences you see from kind of the associate level up to the partner level.
It's actually wild. I think it's a huge transformation, and I'll tell you why. I feel, and again, I hope this doesn't sound self-important, but I feel a much greater responsibility now towards teaching and mentorship. The generation that took me under their wing is now retiring. They've either left the firm or they're leaving. And I'm looking around the room now and I'm thinking, okay, I guess it's now my turn to now take your generation and pass the torch on. And to me, that's a significant responsibility. It I'm a big proponent of education and mentorship. I think you know that. And it's my responsibility to ensure that in 20 years, I've left the firm in good hands in the way that the people who taught me did that. And so it's kind of life altering. You do feel you feel an obligation, but it's more from the perspective of responsibility rather than power, shall we say. Yes, I understand. I'm obviously a partner. We employ people and so forth, and we have the ability to make decisions that would fundamentally alter people's lives. But that's not what this is about. This is about making sure that the firm remains the special place that it was when I started. And that means doing things at our firm that we've always done differently. Things like the partner intensive program, Mario. For students out there who don't know what it is, look it up. I'm not going to get into it, but We've always punched above our weight at our firm, and we've always done things differently. And that's because I fundamentally believe we've always had an open door policy. And the point being that I don't believe in the rigid hierarchy of partner, associate, clerk, assistant, student. Everyone works on a team. Everyone knows that litigation is a team effort, a significant one. And that only works when no one's giving themselves airs. Yes, ostensibly, 9 times out of 10, I'm going to be the one that has to speak in court, but that's only because I have more years under my belt. It's not because I'm better. It's not because I know more. It's only because here we are, and I've got more gray hair than any of you have. Well, you have none. So I think that sort of, you move from being sort of center midfield to up at the front. Now you're the one that's got to score the goals. Pardon the sports analogy, but you're coaching the team now, and it's a raw effort, and everyone has their role to play. Mario, you see my emails when we're working on a file together. Everyone's on that email and everyone has a discrete role. I highlight everyone's name and I'm like, law clerk, do this, assistant, do this. I will do this, student, do this, associate, do this. And then we all come together and, win or lose, I'm so lucky to have the people behind me. And I really, by the time I get to court, I'm standing on their shoulders and it's such a collective effort. And no one's role is more or less important. Mario, you know that my appearance in court is equally dependent on how my clerk put together my materials, as it is on the research that you did, as it is on the proper service letters that were done by my assistant. Like everyone has a role. By the time you're getting to an actual court hearing, there have been 20 people behind you who have each played their role to get you there. So I'm hoping that that's what my role remains as partner is to sort of lead that team for as long as I can until someone else is going to take over that role and do the exact same thing.
One thing I love about this podcast is the way I get to see how people think. And I think I've never heard someone, it sounds like it's something that's so obvious that it is a team effort, but seeing as how just the specifics of every component before you appear in court, it like truly is like you mentioned. You can look at it like a training camp. You can look at it like a soccer or football team, and whatnot. Definitely like that collaborative element super important. But really getting into, I know you've touched up a little bit upon life advice or advice for law students coming up in terms of mooting and things like that. But if we were to specifically talk about young lawyers and law students, what advice would you give those people coming up early in the profession, or even if you can look at it from an angle of what advice would you give first year Marco, if you had to go back to those days at UFT?
I would say don't be afraid to make yourself vulnerable. And so fundamentally what that means is doing things like you've just done, Mo. I don't know you. I didn't know you. And you're like, hey, I'm running this podcast that's hopefully going to provide some guidance to younger generations of lawyers. And I'd like you to appear on it and I'd like to talk to you. Doing that deserves serious applause. Going out into the legal profession and saying, hey, you're a litigator. I'm really interested in your area of the law. Can you meet with me for 5 minutes? I'm a 1L law student. I have no idea what I'm doing. And it even goes back to undergrad. I mean, I mentor students who have aspirations of law and try to walk them through that process. The reason being, I didn't have that. I had to figure it out on my own, and I stumbled a lot for many years as a consequence of really being too afraid to reach out to people. There's the sort of, and I'm going to take this back to a literary quote. I apologize, but E.M. Forster's Howard's End begins with 2 words: only connect. And it's a life lesson. Just connect with people. Go out into the legal profession and make yourself vulnerable and have coffees with people, go out for lunches with people, go to young lawyer events. I wish I had done more of that. I was so focused on trying to learn the practice of law that I neglected it for so many years. And I can't tell you what benefit it brings to you. I've already made this clear as we've already discussed, but here I am in my late 40s and I'm still learning from complete strangers who I've just reached out to and talked to. And this is how things happen, and this is how doors open, and this is how you make connections. But it's not simply to get yourself a job or to get a career. It's to sit there and say, this person has a unique perspective. What can I learn from them? And so what I will tell you versus what Peter Sod will tell you will be very different. But this is the fascinating thing, and this is how we learn from each other, and these are the sorts of perspectives that you need to seek as a young law student, as an undergrad student, as a young lawyer.
I think the don't be afraid to make yourself vulnerable point is extremely important, especially kind of going through 1L and starting 2L with the recruit process and everything and the pressures that it kind of puts on you. I know for my kind of recruit, I didn't do any coffee chats or anything like that. So I think it says something to be able to reach out and start making those connections early.
Well, don't
Um,
underestimate what you did because you didn't know me and you knew your colleagues who had
right.
articles prior to you, but you didn't know me, and you reached out to me one day and you said, "Hey, can you coach our tax mood?" And because I'm such a proficient expert in tax law, I can understand why you did that. But the point being that you knew I was interested in mooting, you knew I had judged it. You and I met. I didn't even know you were hired at my firm when I originally met you, and so you did do it. You did make yourself vulnerable, and like here we are. And I'm still judging the Windsor tax moot somehow, but or sorry, not judging it, coaching it,
Yeah.
which is even worse. Um, and I'm doing that somehow. But I would say kudos to you. You did. You may not have done the coffee chat. So what? You reached out to me, and
Mhm.
here we are, a year and a half out.
I love
Well,
watching this Torkin Manes camaraderie. This is so fascinating to watch from afar. But this is awesome. Yeah, yeah. Go ahead, Mario.
It's better. It's better than when we're throwing knives at each other.
um, so looking ahead, when you're done with your law practice after you've done all your years and everything, um, how would you like your legacy to be remembered? What would you want to be remembered for and kind of your contributions?
Wow, that's intense. Um, I watched Peter's podcast, by the way, Mo, and I know he said I'd like to be remembered as a good person, which is testament to who Peter is, and I get that. I think for me, I want to be known ultimately at the end of this journey as someone who opened doors for kids like me. So kids, sorry, I don't want to get emotional about this, but kids who didn't have lawyers in the family, kids who didn't go to private school, kids who were the child of immigrants, LGBT kids like me that, might have been bullied in my youth. I want them to know that there's a place for you in this profession. And I hope that my small little effort, and it is small, it's, we all bring something small to the table, but it hopefully has a huge impact on creating the space for others. Mario, you don't know this, but like when I walked into my firm 20 years ago, it was me and another partner who were openly out. That has changed significantly at our firm. And it really warms the heart to see the kids of immigrants and LGBT kids, amongst other marginalized groups, thriving and succeeding now in our firm. So I hope that my small efforts at just being who I am with all my flaws, and and I've got many. My husband can attest to that. But just being who I am has opened the door for others. That's what I would like to be known for doing.
Wow, that's an incredibly valuable perspective, and as someone, I think I can relate to the being the son of immigrant parents that grew up with nothing. I mean, going from, my parents in the Middle East to then ending up in the corner of the continent in Vancouver. I think that's a heck of a transition, and to be out here, like you mentioned, certainly a
And
privilege.
look where you are now. Like
I mean,
and
I
it's
don't
true.
compared to you guys. I'm not. I don't want to. Like, it's all about
It's
what you
not
guys have
true,
done.
but like look what happened, right? And it's hard because Mario is the next generation of Italian immigrants after me, or the kids of Italian immigrants. I'm number one. I know the hardships my parents dealt with to basically get me where I am. So
Yeah. No, it's
it's
certainly
hard.
a very valuable perspective, and I think, especially like nowadays, a lot of times with people that are coming in as first generation immigrants, like especially even first lawyers in the family, right? Like things like that. I think there's an amount of an unspoken pressure even amongst the dialogue. So really appreciate you highlighting that, and I'm sure everyone will appreciate your contributions to the legal profession. Ladies and gentlemen, this has been an incredible chat. Marco, thank you so much for taking the time
Thank you.
to connect and be part of this. Mario, thank you so much for being part of it as well. I'm probably going to see you in a few hours at school in some capacity. But this has been incredibly fantastic. For Billable Time, I'm Mo Hussain in Windsor.